Organizations and governments are embracing and frequently immersing in their interactions, transactions, and services in an AI-driven, data-enabled, deep technological infrastructures. And world is at a key turning moment. While this creates a large wave of opportunity for various businesses to grow at an unbelievable rate and scale, it is also necessary and mandate for businesses to be aware of data-related legislations as well as in their concerned markets. This also includes associated issues of IPRs, that is intellectual property rights. With this objective to create awareness in European and Indian SMEs and startups and scale-ups about aspects of the global data protection rights, GDPR, new upcoming Indian data protection regime, and differences in laws governing IPRs with European and Indian startups, who should take into consideration when operating in the European-India business corridor. We have curated this very special session titled as Due Diligence, Data Protection and IPR in the Europe-India Business Corridor. Dear friends, I welcome you all in this session. I'm Ankita Tyagi, Deputy Head IPN Projects in European Business Technology Center, EBTC. I'll be a moderator for this session, and this session has been organized by the EBTC and German India Startup Exchange Program, DINSEP, in association with METI Startup Hub, India IPSME Help Desk, and our knowledge partners, Bohmet and KNS Partners. Now we are ready to pick minds of our brilliant line of experts. And without further delay, I would like to invite our co-organizers, Julian, who is leading project in DINSEP, to say a few words. Julian, over to you.
Thank you very much, Ankita. Also welcome from my side. Really happy to have this event today with great partners. So, and also great to have you as participants and joining in today for this very important topic. Maybe a few words about DINSEP and how we work and how this event actually took place, or why we decided to do this event. DINSEP, so the German Indian Startup Exchange Program, we are an open platform. It's an initiative by the German Startups Association, supported by the German Federal Ministry of Economic Affairs and Climate Action. And as an open platform, we bring together the Indian and German actors that are active or want to be active, are interested in the Indo-German startup ecosystem. And of course, that targets directly or addresses directly startups, Indian and German startups, but also all other parties and actors that are interested, want to be part of it. So we built a network of more than 1,200 startups now that joined our events over the last 4 years, more than 220 organizations from India and Germany, ranging from investors, corporates, universities, incubators, accelerators, business promotion desks, so local governments, government initiatives. So really across the board, and together with our partners, we are organizing various events that range also from promotion to capacity building. And when it comes to capacity building, this is also what we want to do today. So with very targeted and narrowed down topics to really address particular and tackle particular challenges and topics, we organizing different events with different partners. So today I'm really happy that we had the discussion earlier with Hannah and Ankita, talked about, okay, we should really target this GDPR topic and intellectual property again. So after a few rounds of discussions, we also got Bohmet. We involved Daniel here. So this is how the entire event took place. Then Ankita and Hannah, so from EBTC, they asked Mr. Chandra Keska also to join from K&S partner. So this is how the entire event took place. So really happy and looking forward to this really important topic. One note, the event is also being recorded, so just for your information, that we'll share it also later on. In case you have any question, feel free to post it in the chat. We'll try to accommodate and take it up at a relevant point, so also not to disrupt the presentations in between, but we have this Q&A part at the end of our session. So we'll have total up to 90 minutes and try to cover all these particular parts of the bigger topic of GDPR and IPR. So that's it from my side. Really looking forward to this. So thank you for all the panelists also for joining, all the speakers, and of course all the participants joining today. And now back to you, Ankita.
Thanks, Julian. And indeed, you have covered, you have set the tone, how we are going to proceed in the way ahead. So I would like to invite now our first speaker, Hana Andrakova. She is an India IPSME help desk expert, and she'll be portraying on the differences between IPR laws in the EU and India. Hana, over to you, please.
Yes. Can you hear me? Can you see my presentation?
Yes.
Yeah. So first of all, thank you to everyone for joining us for this session. I think it's a wonderful initiative, to jointly organize something with Gincept. We as EBTC, we have been quite active in the IPR space in this Europe-India business corridor. But in this capacity here, I am as an IP expert for EU project called India IPSME Help Desk. And because we have both European and Indian participants, we thought that it would be a great idea just to compare both systems, what particular stakeholders should look for when they're internationalizing to each other jurisdictions. So IP is truly everywhere, I'm sure IP is a mantra of the day. Everybody talks about patents, so technology is protected by patents, books are protected by copyrights, your car, the way how it looks protected by industrial design. So clearly it's something to take into consideration, not only when you're trying to take off your business in your home country, be it India or Germany or anywhere in Europe, but also specifically when you are coming to other country to do that. European Commission has been aware that startups, academia, small SMEs, they have quite limited budget, and hence they came up with a project called IP Help Desk. There are 5 of them, or actually 6 because of the recent addition of Africa. And this is to support SMEs, particularly when they are internationalizing to different jurisdictions. The pillars of the help desk, particularly of the Indian one, is of course the helpline. So obviously we will be talking about several issues, but if any of you have a specific request, then they can either email us, or we can have one-to-one session in regard to what to do when you are coming to India, and or you can just call us as well. Except for the actual helpline, when companies are contacting us, how to proceed when they are coming to Indian market, we also have a training session like this one. So we talk to European SMEs, we meet people at the events, and we try to explain to them what they should be careful about when they're entering Indian market specifically. Except for that, we have created a lot of online resources. Again, this is in layman's terms for people to understand, what IPR is about, in which sectoral, different sectors you can evaluate various IPRs, how that would impact their businesses, etc., etc. So it is a kind of nice package of free of charge support. The help desk, if you check our website, have also IP cost tool. This is not just with India, with any other jurisdiction when you're looking in South America, when you're looking at China, Southeast Asia, where you can check up how much it might cost you to actually, file IPR in that particular country. There is also IP diagnostic tool. So if you're a small company, which is, a startup, which is trying to get there, way how to go about it. So you can do the self-evaluation, how much you actually know about IPR as such. What is also good about this particular project is that there is a policy support and cooperation. So myself, I go to European delegation here in India, I talk to EU member states, I talk to economic counselors, and they pass out the issues which the European companies have when they're coming to India when it comes to IPR protection. So we get the ground information, then we backfeed it to European Commission, and then there is a policy negotiation. Let's say now they are ongoing the IPR conversation between India and the European government. So this is just a quick introduction of the service. So please feel free to check our website. The website will be in the end. If you have any kind of questions about IPR. I have to say this is more applicable for the European participants, but I'm sure the Indian participants will also benefit later on in this presentation in terms of comparison, and then later on when Daniel has quite comprehensive presentation about the patents in Europe. So when we look at India as such, there have been, traditionally, when we look a few years back, there was a bit of bad reputation when we looked or when we talked about IPR. Fortunately, times have changed, I would say majority, the Indian IPR ecosystem got harmonized with the Western approaches, Western standards, especially after TRIPS, signing various agreements. So it's not as volatile, so to say, as it used to be. However, when you are coming to India, there are definitely a few things you should kind of think about. Between I go into details, I just kind of thought it might be interesting to just do little statistics just for you to see, what is the dynamic when you file IPR in Europe, or in India. For the Indian participants, I would like to highlight that in Europe we have two systems. One is the national system in the particular country. We have German representatives here, but I'm Czech, for instance, so there is also Czech Patent Office. And then there would be a European Patent Office and the EU IPO as a national level. So we would have two different systems, which of course is not in India. So when we look at the patents, we will see that Europe, EPO is obviously much larger when it comes to patent filings. But for instance, if you look at trademarks, India, no, the Europe is also also much larger. So India is still despite the, our population being 1.36 billion people, there is still space for growth. As per the latest reports, the growth of the IPR filing in India was around 5% despite COVID last year. So this was just quickly for kind of out of curiosity. And also I mentioned one more thing. Then when we look at the European filings in Europe, there would be around 24-25% of patent applicants. Whereas the biggest, jurisdiction of application, both for patents and trademark, would be actually the US. So of course, this shows that there is more scope for the European companies to come to India, to file the IPR, to expand, to bring their products and services. So I start with patents, which is also my area of expertise. I just pick up some of the highlights. What are the major differences? And I'm also very much looking forward to Dana's presentation later, because his will be a little bit more specific and a little bit more technical. I just wanted to kind of take, so to say, bits and bobs from there and there, because these aspects are also important. What I would like to definitely mention here, India does not have utility model protection. So if you have a minor innovation, I think utility protection is in Germany, is in my home country, Czech Republic, but not all EU countries provide utility design protection. And again, for Indian participants, if you are coming to Europe and you might think that your innovation is more minor than, for EPO patent, this is again something you should investigate, although you would not be able to file your priority, your first application in India. Another issue in India is that Indian patent law does not allow secondary use. That would be more specific in domains like pharma, for instance. If I have a drug and I come to conclusion that my drug can be used for another thing, or a particular invention which was patented for certain use, and then I file for a different one. Indian patent law doesn't allow that. Something which is also very, very important, and I think Daniel will talk about it at length because we will be covering the ICT aspect, is the patentability criteria. There are issues or there are differences when it comes to patentability of computer implemented inventions as well as the pharma. So if your startup or your SME is in the domain, it's definitely worth checking it out before you file for patent in India, whether this particular subject matter is patentable, and if yes, to what extent. For another field, another point which is different, that for certain fields, you actually need special permission. So again, that would be two cases. One is if your invention has biological resources coming from India. I mean, that can be case, let's say, of turmeric, or they can be case of various biological resources. So you have to apply for permission at Biodiversity Authority. Without that permission, Indian Patent Office will not grant your patent. Again, over the time, the process has been streamlined and there are less and less issues securing this permission. Another case is if you have a technology which in some shape or form might be used for for atomic energy. Again, there has to be a separate permission from the Department of Atomic Energy for the patent office to actually grant your application. Otherwise, this, I mean, the particle for the atomic energy would not be considered as patentable. India, I mean, I have been here for many years, and I have to say we love our paper, right? So we like to have and file a lot of forms and stuff like that. And indeed, there is no exception when it comes to patents, because we would have, when I say we, I mean Indian Patent Office, have various requirements when it comes to patent prosecution. One of them is that you are mandated by Indian Patent Office or by the patent law to file details of corresponding patent applications. What does it mean? If you are coming to India with, you have a patent in EU, then you might have to have patent, I don't know, in US, and let's say in Canada. When you are filing your application in India, you have to inform Patent Office about these applications, and any point of the time, if there is change in the procedural stage of this application as well. So the Indian Patent Office is informed about the nature of the proceeding in different jurisdictions. What is a bit difficult here is that if you don't do it, non-compliance with this particular requirement, we call it Section 8, might result in revocation if, let's say, a third party opposes it. So let's say you grant a patent, you have not been complying with this requirement, it can be granted for revocation. So again, this is something which one should be aware of, although it's a formal requirement, and I'm not saying that you have to file it, if you're a day late, there is a problem. Obviously, there is a certain time span when we can do it, but this is something to be careful about. And this is also for Indian applicants, if you file your first application and then you file PCT, and your Indian application is still in the examination phase, you have to also do that as well. That comes across the board. Another kind of sore you can say point in Indian prosecution, or generally in the Indian patent system, is what we call filing working statement. So this is a requirement which is actually applicable after patent is granted. And that means that you as a patent holder, licensee, be it exclusive or non-exclusive, are obliged to inform Patent Office whether your invention was worked or not. By what we mean worked or not, that the invention was commercially exploited in India. Why it's so difficult to, or why it's so kind of challenging, is that you are supposed to tell Patent Office how much turnover you got by selling or manufacturing your invention, and that might be a little bit difficult to find out. Sometimes it's more burdensome for small organization to calculate it. And of course, non-compliance again can lead to, or if you are not working invention, meaning you have a patent and you are not either importing or you're not selling or manufacturing, that can be a reason for compulsory license later on. So this is something which is of course very much objected by the Westerner stakeholders and a lot of Indian industry as well. So another point I'd like to just touch upon here is patent term extension. There would be more for pharma patent where there is a long procedural issues, for various permissions and stuff like that. But in India, we are strict. We just say 20 years and that's it. So there is no extension of patent term. What is wonderful initiative of Indian government is, and I'm sure that's applicable both for our Indian participants as well as our German participants, that past, I think it's 2 years, Indian government has been very active in supporting the SMEs and startups. So there are very low filing fees for patents, this is for all small entities. There is also possibility for startup and SMEs to file for expedited examination and early publication. I have myself personally seen cases where I would get examination reports 6 months after filing the patent application of SME. So there are cases where the patent has been granted within 12 to 18 months. Why is that important, you might ask? It is important because in India, you can enforce your patent after your patent is actually granted. So although India provides the provisional protection, but that's only from from the date of publication to actually, once you granted, you can kind of claim the infringement backwards. So having early patent is, of course, definitely an advantage. So just to sum this up, what you would have to watch for, and again goes for both our Indian and European applicants, filing of working statement once you grant your patent. Watch for patentability criteria, either when you're coming to India or from India to Europe. There are certain fields there might be inconsistency in examination by the Indian Patent Office, particularly for the ICT and pharma inventions. And something which I also should mention is availability of Indian patent data on a free patent databases. At the moment, not all Indian patent data are, let's say, on Espacenet. So when you are searching, doing your prior art search, you should watch out for that. Either use the website of Indian Patent Office or LIPO. So this is just quickly for patents. Now, industrial design. Industrial design, I would say, is again IP right, which has become more popular in India. I would say the major difference is that Europe gives you protection for unregistered design up to 3 years. Whereas in India, unprotected or unregistered design, as well as unregistered patent, is not enforceable. What we see a lot of Western company or EU companies coming to India with the technology which they didn't patent in Europe, or they didn't file application, or filed elsewhere, and or didn't file in India, and they find out that they cannot file in India anymore, and what to do if there is a case of infringement, because their rights are not, they have not filed for patent on design, and hence the enforcement becomes extremely difficult. Layered protection, whereas the European system offers some sort of overlap of the rights, in India it's not the case. Particularly, the protection between copyright and industrial design. In India, there is, I think it's in Copyright Act. If you have, let's say, piece of art or some print, which can be manufactured by the industrial process more than 50 times, hence that particular piece of art is not eligible for copyright protection and has to be protected as an industrial design. It might sound a little bit confusing. It's basically to show, because copyright gives you right for at least 60 years, whereas industrial design for 15. So if you are coming to the country with let's say you have a fashion item and you think, okay, I'm gonna file as a copyright, and then I come to India and I will manufacture it in hundreds, and I'm gonna be protected for 60 years, that would not be the case in India. It would be just give you 15 if you file for industrial design. And again, because we are not yet part of the Hague system, you would have to file your application as a convention application, meaning within 6 months from filing application in Europe, you have to file in India. And again, same, the vice versa. If you file your application in India, you have only 6 months to file it in Europe. Copyright. So India is a part of Berne Convention. I think copyright might be something we don't talk about much in Europe because it's automatic protection. In India is the case as well. India is signatory to Berne Convention. So the moment the work is created, the copyright comes to force, so to say. However, when the infringement happens and you go to court to stop the infringer, having a copyright registration is definitely, I mean, in some cases we used to say mandatory. There have been various court decisions having various opinions about it, but it's always advisable, to file copyright. What I don't have here in India, since the software is not patentable, software again is protected in India under copyright under literary works. I don't know how much time I have, Ankita, just, tell me if I'm over, shooting off. Another IP right which I want to talk about is a trademark, because trademarks are, the best way, how to take your business off, because, building up your brand, having the logo, and, I mean, we all know all these big brands like Apple, Adidas, it's a very heavy trademark field. So there would be definitely fields where having a trademark is actually absolutely essential for your business. At EU level, unregistered trademark are not protected, whereas in India, unregistered trademark can be protected under, as we call, common law doctrine passing off. Again, although that provision is there in Indian law, you have to prove that your trademark has been well established in the market. So again, if you, by the time you come, and if you're not particularly active and somebody tends to, copy it from you, and then you struggle to prove that you have been sufficiently, active in India, you have built sufficient reputation and goodwill, then again, it might become a little bit difficult. So again, I always give advice whenever I talk to Europeans, and I'm sure this will be same for our Indian stakeholders, whenever you are thinking about other jurisdiction, do your trademark search and file your trademark as soon as possible. India is also a country which uses first to use versus first to file principle. So whereas in Europe, the moment you file your application, a trademark application, you are good. In India, let's say if you have a party which travels to Europe and they see something somewhere, they come to India and they start manufacturing something or provide a service under the trademark they saw at the trip in Europe, let's say. So they start manufacturing first. There is a provision for well-known trademark, but they have to be really well-known trademarks. So again, then it becomes a little bit difficult. Again, if you're a company and you think about coming to India, just bringing the goods, albeit in small quantities, to have the first to use is also very important. Although I don't want to scare anybody, there are of course ways, if that happens, how to kind of go to court, have the registration cancelled, and so on and so on. But again, there is additional cost. There are also slightly different grounds for examination in India. It's just, as we call it, relative and absolute grounds. In India, the trademark must not be similar or identical to any well-known trademark or any, goods looking alike. Again, when we look at the challenges, as I said, the first to use is definitely considered a little bit of issues. So, watch out for that. Infringement, again, because it's always easier to, enforce under the Trademark Act as opposed to, unregistered trademark under the common law doctrine passing off. So the advice would be, again, register as soon as possible. So, and last and least is the trade secrets. Trade secrets, in EU, the protection has been pretty much harmonized. I have myself spoken to company which has amazing way how they use trade secrets for their own business. They have I think they were Dutch. They filed the trademark with the local authority, and they have the certificate of trade secret. They have a certificate of the trade secret, and are using the technology in very wise way, the way how they know how, and they really leverage this particular IPR for the business. Again, in India, we do not have uniform legislation, so trade secrets are protected under various laws. Usually, it's the confidential information. Indian Penal Code, the Competition Act, and so on. So when there is a leakage on information, depending on what the case is, that you would have to use that particular law. So it becomes a little bit burdensome. So again, if your model is on, protecting your innovation as a trade secret, okay, and you think about coming in India, it is definitely worth checking it out, how to go about it. And very quickly, last and least, it's the enforcement. I don't know whether Daniel will talk about it because there are patent attorneys in the EU. They will be more informed how it actually works in Europe. But we know that IP holders can file civil action against infringer, and the criminal law are not harmonized across Europe because, again, it depends if you have a national patent or you have the EPO patent, that it will vary. In India, as I said, you can file criminal and civil action. Again, depends on what rights, as we said, unregistered trademark, unregistered patents and designs, you cannot really file criminal action. But for the rest, like geographication, trademark, you can do that. Right, so that's all from my end. I don't know how I'm running out of time. So thank you for watching, and I hope it was interesting for you. Please reach out to us. There will be also, we are sharing feedback for this session, so please share your feedback with us. And yeah, keep us, keep posted on our LinkedIn. We've organized a lot of training events for the European SMEs. And yeah, and so that's all from my end, and I'll pass word back to Ankita. Ankita, over to you.
Thanks, Hannah, for sharing, in such a comprehensive manner, the differences between Indian and European IP ecosystem, and also from the feedback or input from other stakeholders, as the government side or the European stakeholders, Indian companies. In Parliament also, they have tabled one suggestion report wherein they are thinking to incorporate trade secret as well as utility model in India, because now universities and government side institutions are working towards in R&D and filing more and more IP. So that 10 cents from my side. So now next speakers will be Dr. Daniel Herman from Vermet & Vermet. He'll be focusing on patents from EU perspective, more towards strategic perspective on various characteristics of the patent systems from Germany, Europe, EU, and WIPO. He is partner in Vermet & Vermet. He's a German as well as European patent attorney, and his expertise lies in computer implemented inventions, medical devices, and physics. Dr. Daniel, over to you, please.
Yeah, thank you very much, Ankita, for the introduction. I will share my screen. Is it coming up? Great. Yeah, so thanks to the organizers, EBTC and GINSEP. We have been collaborating for some time now. It's very fruitful and good collaboration, and we, of course, are very happy to contribute to such events that are hopefully to the benefit of both the German or European companies and Indian companies. So today I have the pleasure to talk about patents from a European perspective. Before I do that, just a short introduction. I'm a European and German patent attorney. Ankita has already introduced me. I just want to mention that our law firm is a European IP law firm, so we usually handle German IP law and European-wide IP law and all aspects of that associated with all the IP rights we have heard about from Hannah already. And in this context, we are not only work with big companies, but also startups and SMEs, which are very important to us. As Ankita mentioned, I handle a lot of computer implemented inventions. I will not touch that point today too much, because I could talk about this topic for probably 1 or 2 hours, and this would be a separate presentation. So this would be another event, but maybe finally, the basis also of our collaboration is that I'm a board member of TIE Germany. Some of our members are here today. We, of course, collaborate very much with GINSEP and organize such events or contribute to such events. So I want to give my presentation the following outline. I will start with part one. I want to talk about patent strategy, some aspects, strategic aspects you should know when we talk about patents. This relates to why to have patents in the first place and how to approach this process. Then I want to move on to part 2, 3, and 4, where I want to highlight some characteristics of the patent systems in Germany on the European level of the European Patent Office and the international patent application, and then I will conclude my presentation. So let's now talk about patent strategy. In particular, why do you want to patent anything in the first place? So the 4IP European Research Council has identified 4 main reasons to patent, and I want to highlight them here. So the first main and maybe most obvious reason is market access. Market access has a active and passive side, where the active side is here shown with a stop sign. So of course, when you get a patent granted for your technical invention, this not only allows you to use your invention, but also allows you to prevent others from copying it, from entering the market with the same invention. So it allows you to put a stop sign on the market. And also via license agreements, you can decide who should or should not enter the market. You may allow some of your competitors or friendly companies and others not. So you are in the driver's seat. The passive side is what we call freedom to operate. So as a market player in Germany and Europe, you are obliged to monitor patent rights by competitors, third parties regularly, and identify relevant patents and respect them to avoid infringing them. The second reason is negotiation, because patents are, of course, a tool during negotiations. It can be negotiations with a collaborator or joint ventures or the like, and especially if you are a smaller company, the patents must also be respected by the bigger one, and it gives you leverage in these negotiations. The third reason is funding. If you get a patent, it's some of the companies mainly look at patents as an additional cost, but actually it's more an asset, because your intellectual property rights and in particular patents increase your company value. They also attract investors, because investors like patents, and they usually quite frequently and early in the process ask about patents and whether or not a startup has a patent. And so it allows you to get more funding. And the fourth reason is a strategic reason. Via the patents and the patent process, you show internally to your employees and also externally to the market how innovative you are. And now I want to shortly highlight how it works. So how does the patent process work? Here, it's quite similar in Europe to other jurisdictions, but maybe it's worthwhile to talk about it shortly and then highlight some differences. So first, you would draft a patent application, usually together with your patent attorney. And this is then filed at the patent office, and it will be searched by the patent office for prior art. It will be examined, and whether or not the patentability requirements in this jurisdiction are fulfilled, and then the patent will be granted or not. And after the patent grant, usually some post-grant proceedings are available, like opposition, revocation proceedings, infringement proceedings. If the claims of your application, which define the scope of protection you want to have, fulfill all requirements, then farm up, it will be directly granted. If not in this breadth, they are allowable, but some limited version of that, then you are allowed to amend the application. So when you are in this intermediate blue thumb, and if nothing is disclosed in your application which is allowable, then it will be refused. So thumb down. I've mentioned that you can amend your claims usually, and here in Europe and also in Germany, but especially at the European Patent Office level, the requirements for original disclosure and the possibility to amend your claims are quite limited. This is a specific feature, I would say, in Europe, has some historic reasons. So this is why the stone is here. When you file your application, whatever you have described in your application is, so to say, carved in stone once you file the application with the patent office. This is in the picture here, of course, already, but it's a closer reality. So you can only take away information from your application, but you cannot add information to your application once you've filed it. There is, of course, the room to perform amendments, but the room is more limited compared to other jurisdictions. And this is one of the specialities in Europe, but we have also others. We have some differences with regard to how we define prior art. I will come to that. And we have talked about software, how to patent software. I think Europe is the jurisdiction worldwide which is at the frontier of developing rules, what can be patented and what should not be patented. So in Europe, the case law has started very early on developing criteria of which kind of software should be patented and what should not be patented. And today, actually, US patent attorneys always tell me in Europe, you have a big advantage in software that the requirements are predictable. They might be not easy and they are strict, but they are predictable. And this is a big advantage compared to, I would say, some other jurisdictions that if you go down that road and invest all these financial resources and time to patent software invention, you should at least somehow be able to assess the chances of success. But now let's move on to what are the requirements for performing a search and for getting patents granted. Important to notice that inventions can be patented that are fulfilling the 4 patentability requirements. These are set out here in Article 52 EPC, the European Patent Convention. The first requirement is you have to have an invention in the field of technology. So when we talk about patents, we talk about technology. The second requirement, it must be new, so novel. The third requirement, your invention should be based on an inventive step, the third requirement. So it should go beyond what the skilled person commonly does. And the fourth requirement is successibility to industrial application, which is usually not an issue. Normally, we talk about novelty and inventive step. These are the 2 main requirements for any invention. Article 54 then defines what a novel invention is, and this gives us some information on prior art, because it defines that an invention shall be considered new if it does not form part of the state of the art. So the question is, what is the state of the art? So the state of the art is the thing that is searched by the patent office. They are searching for prior art. What is defined as a state of the art? And this is given here. The state of the art shall be held to comprise everything made available to the public by means of a written or oral description, by use or in any other way before the date of filing of a European patent application. So we have written oral disclosures, we have use such as selling the product and any other way. So basically any way to disclose your invention to a third party, if it's not under non-disclosure agreement, is prior art. And if you do that before the filing date of your patent application, you basically destroy your own application, or at least cause some trouble, because you create your own prior art, and you have to overcome your own prior art with your later filed application. So my strong recommendation is, before you talk about your product, your invention to third parties, which would reveal some of your some aspects of your technical invention, first file your patent application to get filing date, and after that you can talk about it. But before that, you should not do that, even not with an NDA, because NDAs can be broken. So this is the clear recommendation here. And behind that is all that Europe is the first to file system. So this means the right to a patent of the right to a grant of a patent for a given invention lies with the first person to file a patent application for protection, and it does not matter when the invention was made. And everything disclosed before this filing date is prior art. And in the US, they had a different system. They moved closer to the first to file system. So this first to file system is the system that is on a global scale more frequently used, and also in Europe and Germany. So the question is then how to file, where to file. So you normally file your patent application first in your primary market. The primary market can be your home market, but does not necessarily have to be your home market. It's a market where you want to get protection quickly rather than later. And once you have filed this first filing, you have 12 months after this filing date to scale out your patent protection globally, namely by filing patent applications in other jurisdictions via the international applications or with direct applications in these other jurisdictions. And in the time between, since you have already received your filing date or your first filing, you can market your product, because your second filing will inherit the filing date of your first filing if you describe the same invention in the second filing. And by this, you can have a second filing, for example, in the US, having the same effective first filing date as this first filing, which was, for example, in India. And this is how you can scale up the patent protection globally, and which the patent applications are available now for you for the first filing and for the second filing. I will start with some specifics about German patents and utility models. We have heard from Hannah that there are some very nice and interesting specifics in Germany. And Germany has, I think, a quite unique system, because it offers some strategic options not available in other jurisdictions. For example, when we talk about patents, it provides a quite unique opportunity that you can file a German patent application, but you can defer examination up to 7 years from a filing date, which means you can keep your application dormant and activate it on demand. So whenever you want to start the patent process, you can do that. There's no automatic process leading up to examination. So you have 7 years to file a requested examination as you wish. The German patent system is quite cost efficient, a factor of 7 less compared to the EPO. And you can file the German national phase applications in parallel with European applications. So you can have German and European patent applications in parallel. Also, there are some specifics regarding double patenting. I will come to that later. There's the unitary patent system coming up. You can have double patenting with that. So you can have a unitary patent and a German patent. This is a specific advantage also of the German system. But as Hannah mentioned, utility models. In Germany, we have utility models. Not all countries have this small brother of the patent, you may call it. Utility models give a protection of 10 years, the patent 20 years. It has a more relaxed prior art definition. For example, prior art is only written disclosures and use in Germany. I've mentioned before, normally you have all kinds of means that can make an invention available to the public, including oral description, for example, or use anywhere. This does not apply to utility models. Here, only written disclosures and use in Germany. So if you have a use somewhere else outside of Germany and still want to get protection in Germany, you can think about a utility model, because then misuse outside of Germany is not prior art. And you can get the utility model registered quite quickly, within a few months at low cost, and it's a fully enforceable right. And now comes a very interesting feature which connects the utility models with the patents, with the German patent and with the European patent, namely the so-called branching off of a utility model from patents. I think this is a very extremely unique opportunity in Germany, because if you have a patent application pending where you designate Germany, for example, you have a German patent application, you have a European patent application, or even an international PCT patent application, you can file or branch off a utility model from this pending patent application with its own claims targeted to a product, for example, you want to attack by some competitor. And as I mentioned, it's quite cheap, and it's a very unique way to get an enforceable right quite quickly and in a targeted manner. So after I've talked about German specifics, I now want to go one level higher to the European level. Here we traditionally have the so-called European bundle patents. So European Patent Organization has established a common grant proceedings, which is applicable for 38 member states, which are highlighted here in red in Europe. So what happens, you file a European patent application with the European Patent Office, and there will be a search and examination. Patent will be granted with effect for all of these countries. And then after this stage of this common grant proceedings applicable for all states, you then have to perform a validation, the so-called validation step. So you have to make a final decision which of these 38 countries you finally want to validate the patent. So you have already the advantage that you don't have to launch 38 grant proceedings. You only need one at the EPO. But after that, you then have to perform individual steps after the grant to validate the patent in these countries, which means appointing a representative or filing at least claim translations. So this is an additional step, but nevertheless already some efficiency gain because you have this common grant proceedings. The European patent is a success story. So over many years, there has been a high demand for European patents. We have seen the numbers already from Hannah, about 180,000 per year patent applications filed, and the number is increasing. Patent applications in Europe are not only filed by European countries or European companies, but also from American companies, of course, and from Asian companies. And there's a more or less steady increase in the number of applications filed, as you can see on the slide. When we look a bit closer, I make a breakdown by technology. So this here is shown the number of European patent applications filed with the European Patent Office for the 10 technology fields with the largest number of applications in 2020. We see here that in the top row, medical technology, digital communication, computer technology, electronics, transport. So these are these modern technologies, what we also sometimes call emerging technologies, digital health, IoT, and so on. So these are driving these modern technologies and lead to increasing filing numbers in addition to the conventional technologies. So Europe is actually a key market for these emerging technologies, and we see a rapid increase for these types of applications, actually also including artificial intelligence. There has also been a huge increase since the last years. I would say the increase for this technology area is going on since the year 2000. One aspect the European Patent Office is very proud of is its unique and very good search tools. So they would say they have the world's most comprehensive prior art collection. It's definitely among the most comprehensive ones. So they have search tools and database collections of documents which cover these countries here. So they will find applications, patent applications, conference proceedings, scientific articles, internet disclosures in any language for these countries. And for internet disclosures, for example, we use Wayback Machine. So if you want to get a really good search and get some certainty if your invention is patentable, filing a European patent application would be one way of doing that, because you get a search report which is based on this very comprehensive prior art collection. And based on such search results, you can then make a decision whether or not it makes sense to file further applications globally. So these are the advantages of a European system. Now some very current news for you. In addition to the European patent, the traditional European patent system, there's the unitary patent coming up, and it will start in autumn 2022, beginning of 2023. And you see here, this will be for the first time a quasi-EU-wide a patent, which gives you protection in all of the 25 participating EU countries with one application. And so it's you get rid of the validation step I've mentioned before the European patent, and have also only to file one request and a translation and pay one fee for all of these states. Great Britain is not part of the system because they left the European Union. And here's a slide summarizing it. So basically you get a uniform protection with equal effect for all of these countries, and there will be a centralized approach to obtain the patent via the European Patent Office in the same way as so far, but also be able to enforce and defend this patent via a new unified patent court to be established. It will be in Paris and Munich, and so there will be one patent application leading to one patent in all of these countries being enforced at the same time in all of these countries. You can defend this patent and enforce this patent in a unified manner at the Unified Patent Court, whereas in the current system, you would have these national parts of a European patent and would have to launch national proceedings to defend or attack a patent, and also infringement is handled by the national courts. So you would have in all of these validated countries individual court proceedings, but the new system gives you one court handling all of these court proceedings for defending and enforcing. But the traditional European patents and the national patents will coexist, so these systems will be maintained. How it's done, here it's just a short introduction. On the left side, you see how the European patent is obtained. Nothing changes here. But then 1 month after the European patent is granted, you file a request for what we call unitary effect, and then you get an EU-wide patent in a manner which is cost-effective, because this request is even free of charge. Some numbers, I was asked to give some numbers. Here's a comparison of the renewal fees. So every year for a patent application, you have to pay renewal fees. And for the unitary patent, they have decided that the single renewal fee you have to pay is equal to the renewal fees which would be due for the top 4 countries: Germany, France, formerly UK, now Italy, and Netherlands. And so you see here in the green column the renewal fees for the unitary patent, and the validation in top 4 is basically the same number because it was calculated on that base principle. And if you combine that, you get, and if you compare this number in the green column to the other 2 columns on the right-hand side, validation in 25 member states, you of course see that validating in all of these member states would be much more costly compared to having the single fee for the unitary patent. But of course, if you compare it with validating in 3 countries like Germany, France, and UK, which is often done for the European patent, the costs would be less. So I would say the unitary patent is interesting for you if you think about getting protection in 4 or more countries in Europe. Otherwise, it makes more sense to work with the European bundle patent. Finally, a slide on the international patent application. I've mentioned you can scale globally, and here, after you have filed your first filing in your primary market, you can, as mentioned, you have 12 months to file globally, and a very convenient way to do that is to file a so-called international PCT application, the Patent Cooperation Treaty it's called, and claim priority to your first filing in your primary market, so you inherit the application date. And this is also a common filing system. So I've mentioned the European system is a common grant proceeding for all of these countries. Here, this international system is a common filing system. So you don't get a patent out of this directly, but you can file in a common way or unified way your application for up to 153 countries. These blue labeled countries here are all part of the PCT, and you can, by filing one application, secure your application for all of these countries. And after 31 months, depending on the country, you then have to decide in which of these blue countries you really want to go and start the respective grant proceedings then. And before you do that, you will of course receive a search report and some preliminary opinion on the international level to give you some guidance. So now I want to conclude my presentation. What I've highlighted is that patents are a very important tool. It's not only a source of costs, it's an asset, and it not only protects your research and development, which you have developed so nicely and with putting all your efforts into it. You can also, by patents, decide who can enter the market through license agreements. So it gives you the possibility to enter a stop sign on the market. It gives you leverage during negotiations. You build company assets, attract funding, and so on. So a patent goes beyond the mere intellectual property right. It's interrelated with your business. And before you enter the market or talk about your invention to third parties, very important, kindly note that first file a patent application or utility model to secure your filing date before you hurt yourself by creating your own disclosure. At least in Europe, this would be a problem. And apart from patents, get your other IP homeworks done. We will hear later about data protections. We have heard about trademarks, designs, and other things. So it's a whole bundle of things that should be taken into account. I've highlighted the 12 months. So after the first filing, you have 12 months to scale your invention globally via filing European applications, international applications, for example. And today, the startups are international from day one. So you need a global IP strategy. We are in the 21st century. Also, I've highlighted that Germany offers some quite unique opportunities for you. I've mentioned deferred examination, 7 years, branching of utility models, a cheap way to get some rights. And utility models also have some relaxed prior art definitions which might be of use. Europe is a key market for patentee, especially when we talk about the emerging technologies. There's been a stable demand for EP patents, and the number is increasing. And the EPO is very proud of its search tool and comprehensive database. So while the official fees might be not low, you get a good search result. And when we talk about these legal aspects, I've mentioned, for example, original disclosure, amending claims, special definitions of prior art, and special rules how to get software patented. Since there are only limited room to perform amendments of claims in Europe and in Germany, when you draft the applications, take these legal requirements into account at the drafting stage, because later on it's only limited room to fix these issues and it will become more costly. An outlook in autumn this year, beginning of next year, you will have an additional option in Europe, the unitary patent, and one patent effective in up to 25 EU states. No validation needed anymore, a single renew fee to be paid, which is equal to 4 states. And you will have a centralized approach via the new unified patent court, not only to obtain the patent via the EPO, but also to enforce and defend your patent. And this will, of course, give you some efficiencies. But on the downside, one should also note you have unified patent, which will be enforced in all of these countries. So it can also fall in all of these countries at the same time, whereas in the traditional bundle patent, you would have these individual proceedings and parts of a European patent. So you have some not only advantages, but also some disadvantages. And here you need to tailor your strategy for your particular patent applications. I hope this gave you some insights in how we in Europe and Germany see patents, benefit of patents, why to patent, different systems we have, specific characteristics of the different jurisdictions, and what is coming up. If you have any questions, feel free to post in the chat or send me an email. Thank you.
Thank you, Daniel. I mean, this is such a wonderful and You have shared each and every aspect of a very important, I must say, IP strategy, not just an IP strategy and your business strategy, because IP strategy is a very integral part of creating a good business strategy, especially
Absolutely.
for born global startups and scale ups. Nowadays, not SMEs or big businesses just, but these startups and scale ups are born global and they're looking for each and every jurisdiction. So thank you, Daniel. Now we are going to move ahead in a very, I must say, exciting session that's on data protection from European and Indian perspective. And we are going to have our speakers, Dr. Alexander Thamer from Bohmet and Homer, who will be representing data protection aspects from European angle, and Dr. S. Chandrasekhar, Head Digital and Cyber Practice from KNS Partner. Dr. Alexander, expert in trademark, competition, copyright law, and he also advises on e-commerce and IT services, and also on contractual consumer protection law issues, with the special focus on software copyright law and IT contracts. And Dr. S. Chandrasekhar will be leading the digital and cyber practice vertical in Kenes Partners. He is leading, and he's a former civil servant, technocrat, and tech policy expert. And very interestingly, he was responsible for driving large-scale capital project, which includes hugely successful rollout of this government India's passport seva project. So welcome both of you. We'll start with Dr. Alexander. Over to you, please.
Yeah, hello from my side. I just am encountering some technical issues. Can you hear me?
Yes.
But the picture is missing, as I'm seeing right now, because there is currently my colleague next door is setting up a new table, and apparently the internet connection just got disconnected. I will try once to reconnect and establish my picture. I'll be back in 1 second if that's okay.
Yeah, that would be okay, but we can start with Dr. S. Chandrasekhar.
Yeah, that would be best, I think. Then I'll just do it after this.
Okay, definitely.
Okay, good.
So, yeah,
So
sir, over to you, please.
yeah, so it finally took the internet to put me on a spot. So happy to be here. Thank you for the opportunity and a very good afternoon to all of you. So see, well, the entire world is currently awash with this concept of data, and everybody is talking about data. Data is being sliced and diced in different ways, but data has been around since time immemorial. So what has changed? So what has changed is SMAC, social, mobile, analytics, and computing. So these four technology trends have suddenly transformed the mundane data into the new oil. It's something like the spectrum. Spectrum always existed, but it was only after Marconi discovered the radio waves or the use of radio waves that spectrum became a valuable asset. So now data is a very valuable asset. And as we go forward, the volume of data that is being produced by both humans and machines, the Internet of Things, etc., is completely exploding. And governments around the world are trying to wrap their heads around this huge tsunami of data. As we talk, I am told that about 70 countries are currently in various stages of forming their own data protection regulation. The Europeans were the fastest and they were quick off the block. And the data protection debate started in India soon after the GDPR debate started. In fact, the debate was quite old. It had actually started in 2011, and then it went into cold storage. And in 2018, we wanted to catch up with the Europeans, primarily because there is a lot of flow of data from Europe to India and vice versa, because India is one of the centers for processing data. So as is true in India, as Henna can vouch for, everything in India is convoluted, long, noisy, and there are a lot of discussions, debates, parliamentary debates, special committee, etc., etc. But now we have reached a position where the bill is about to be passed. There is a lot of bipartisan support for the bill, and we don't envisage any major hiccups. The Indian Data Protection Bill is also called the GDPR on steroids. So it has most of the provisions of GDPR, but with some special Indian kind of nuances. And in some areas, it is a little tougher than GDPR. So, what does this regulation seek to protect? So, from reading of the regulation, one can glean that consumer privacy is very important, national security is important, and the regulation of data and the economy around data, that is important. So the data protection bill seeks to control or wrap or handle these three major issues. From the intellectual property point of view, I'm not an expert in this area. The bill is quite silent because there are several areas which can be challenging from the intellectual property point of view. For example, one could argue that the way you design a data set or the way a data set is made, that could constitute intellectual property. So the bill is silent about those aspects. The second thing is that India, for the first time around the world, first time in the world, has combined what is known as non-personal data into the personal data protection regulation, because the lawmakers have argued that, in my view, argued wrongly, that most non personal data is actually generated from human beings, like your heart rate monitor or your Apple Watch or somebody monitoring your blood pressure. So these are all examples of non personal data. They do have an implication on personal data. It is possible to identify a person from quite a bit of non personal data. So areas of non personal data which would have an impact on personal data are being covered in this regulation. This regulation also intends to cover social media. There are some new concepts in India as compared to other countries, like the concept of significant data fiduciaries, like the concept of having extra regulations on social media intermediaries who are and so on and so forth. So, in the interest of time, I'll just confine myself to some of the big areas which could concern bilateral trade. One thing is data localization. Data localization in India is a little more strict as compared to the European Union. In India, they are classifying data as sensitive personal data and critical personal data. In the case of sensitive personal data, they are saying that it can be shipped outside India for processing, but it has to come back to India after the processing is done. In the case of critical personal data, which they have not defined, they have said that it cannot leave the country. I expect that this personal data may be about data of army personnel and pension data and things like that, breach of which can cause significant strategic damage. So, um the bill also gives a transition period. The initial drafts of the bill did not give a transition period for the bill to be rolled out. So that was a concern of the industry as to how can the industry quickly adapt to the new regulation. But now there is a well-defined transition period, the period for establishing the new data protection authority, and then the period for companies to register themselves, and so on and so forth. As far as processing of data is concerned, in India, they have kept the age of processing for children's data as 18, and any entity that processes the data of children will be termed as a significant data fiduciary with much higher compliance norms. Then there is a lot of, and again, for the very first time in the world, there is an accent on the hardware. Usually laws around the world, they talk about social media and software, but for the first time, the regulation is, and the debate around the regulation is talking about hardware and how data from hardware should be controlled. And there is a lot of emphasis on innovation because we're talking about SME. So the new data regulation, it talks about the possibility of creating regulatory sandboxes where a new product or a new idea can be tested without having the burden some regulatory overhead, so that idea can be tested in a regulatory sandbox. So that is all that I have. I will stop here and probably I can cover the rest in my Q&A. Thank you so much.
Well, thank you very much. I will take over from here and give a little insight into the European and German data protection regulation. I think I will just start with my slides. So can everybody see the slides? Perfect. Yeah, thank you very much for this very informative insight into the Indian data protection regulation. I will now give a very short and quick introduction into the European system. Just a few words about myself before I start. I'm an associated lawyer at Böhmert & Böhmert, and I'm specialized in more like the traditional IP areas like copyright law and trademark law. But I and we at Böhmert & Böhmert have done in the past and are doing more and more a more modern area like data and data protection law, as it has become more important over the past few years, and its importance is even rising in it's even expected to rise in the next few years. The reason for this is pretty simple. As we have just heard, the processing and use of data has become a very important factor for every business. And if you want to do business in Europe, chances are pretty high you either use for your business data of individuals, personal data of individuals in Europe, or your business is even based on the use and processing of personal data of individuals in Europe. So while the data itself is, at least as of yet, not protected like other intellectual property, there is actually some legislative endeavors going into this direction. But as of yet, it is not protected like other intellectual property. It is heavily regulated. So when you do business and you use personal data, you have to observe, you have to comply with the GDPR in the EU. So there are several key factors why data protection is important, and the most important one, of course, are the regulatory expectations. Breaches of the GDPR are subject to severe fines, and in the last year, 2021, we have seen some record fines from data protection agencies in the EU for companies like Amazon and Google's. And we see that this is becoming more and more important, and that the enforcement of the GDPR is becoming more tough, more thorough. So there is very important factors why to observe these rules, these regulations. And in this short presentation, I will give you a really quick introduction into how we at Böhmert & Böhmert will assist, or what steps to follow when setting up this data compliance with the GDPR. First and foremost, why is it important for companies outside of the EU to follow these rules? It's simple. The GDPR, the European General Data Protection Regulation, has a very broad scope of protection, meaning that essentially all businesses collecting or holding personal data of EU residents have to follow the regulations. So even if you're operating from outside of the EU, you have to follow the GDPR if you are collecting or holding personal data of EU residents. How do you follow these rules? Well, there is several key principles of the GDPR, which I have put up onto this slide, and which I will not go into detail with all of them. I just want to point out two of the most important ones, which are the lawfulness and the transparency. Those are the really core basic requirements you have to follow when setting up your data protection compliance. What does this mean? Well, first and foremost, you have to have a lawful basis when you use and process data, personal data of EU residents. Now, what can this lawful basis be? It is actually stipulated in the GDPR in Article 6. There is several grounds which you can base your data use on. And two of the most important grounds, two of the most used and popular ones are the consent and the legitimate interest. Consent basically means that once a user, once an individual gives his or her consent to the use of his data, you can use it as you wish. But the problem here is only if this consent was informed. So only if you have given the user enough information on how you want to use the data, who else might use the data, if you want to transfer the data somewhere else, only if the user has been informed of all this, can he or she give an informed consent to the use of the data. And that is why you will see in the EU some of these checkboxes for Google, for example, where there is a wall of text informing you about all the eventualities of the data use. And only if you're informed of all of this can you give your consent to this. So that is one of the major problems and one of the reasons why many of the checkboxes that you see are actually not compliant with the GDPR, because they do not give enough information. Only if you are informed about the use can you give consent. That is one important thing to consider when you base your use on the consent of the user. Another important thing to consider when you base your use on the consent of the user is that the user can at any time withdraw his or her consent, meaning that you are left without any consent and you must stop the use of the data immediately and delete it. So if you base your whole business on the consent, you might consider, or you must consider, that this consent can be withdrawn at any moment. Another very important factor, another very important basis for data use would be the legitimate interest. Now, legitimate interest means that any lawful interest of your company can be used for data use, data processing. And that, of course, is very tempting, and it is often abused, I would say, because you will find in data privacy policies often this text, we will use your data based on Article 6G, that is the legitimate interest, because we want to do marketing with your data. But this by itself is actually not enough, because you always have to weigh your legitimate interest with the interest of the individual to protect his or her data. And the outcome of this can very well be that the use you intend is actually not allowed. And then you have to check the balance, and then you have to ensure that this balance between the two interests is not out of weight. So relying solely on the legitimate interest will usually not be enough. You will also have to follow, you will also have to do this balancing of the interest, and only then can you base your use on the legitimate interest. So this is usually the first step we do when setting up data compliance. That is finding the lawful basis, finding the right lawful basis for your individual purpose, for your individual use, and setting it up in a way that is compliant with the GDPR. The next key principle I want to take a look into is the transparency that I've just delved into a little bit. That means you always have to inform every individual before collecting his or her personal data exactly about how this data is used, which data is used, what the purpose of the processing of the data is, what legal basis your use is based on, how long you store the data, if you transfer the data outside of the EU, and who else might receive this data. This is a very important factor of the GDPR, and it is a requirement which goes beyond some of other regimes like the US regulations. And that is the reason why many privacy policies that are based on the US system will not easily apply in the EU, because these policies usually are not thorough enough in this point. You have to really check your whole data flow, check what data do you collect, what personal data do you use, in which way do you use it, who else processes it, which purpose is followed. You have to do a very thorough checkup of all these factors, and then you have to inform the user about all of this. And only if you do so can your data use and process be compliant with the GDPR. These are two of the most important key factors of the GDPR, the lawfulness and the transparency. And now I just want to give one other important insight, which is especially important when doing business from outside of the EU. Here we have a principle of the GDPR, which says whenever you transfer data to non-EU territory, you must ensure that the data protection standard there is comparable to the one within the EU. And this is actually not so easy, because it has to be approved by the European Commission that this is indeed the case. So how do you proceed here? Well, the easiest way, where you don't have to worry too much about anything at all, is if your country happens to be approved by the Commission in an adequacy decision. The EU checks on countries, decides whether their standard is the same or comparable to the EU, and when it decides that is the case, then it gives out an adequacy decision. Unfortunately, this has happened only very few times and for very few countries. That is, I think, Canada, Switzerland, and Japan at the moment. And India, unfortunately, at the moment at least, it is not included in this list. And while there is talks about India in this regard, it is not in the foreseeable future that India will be included in this list. So how do you ensure it without this adequacy decision? Well, you have to give your company binding corporate rules, which ensure that your standards are the same. However, when you do so on your own, you have to have these corporate rules again be approved by the European Commission. To avoid this, you might, and this is actually the standard everyone uses, you might use the standard contractual clauses. Those are clauses which are pre-approved, so to say, by the European Commission, which are available on the internet and which you can implement for your company to ensure that the standards at your company in your country are the same or comparable to the ones in the EU. However, when implementing those standards, you still have to follow some rules which have been established by the CGEU in the highest court in Europe, regarding some judgments regarding the transfer of data to the USA, which essentially mean you can't only implement them, you can't only put them up, you also have to ensure that they can be followed. That they will be followed, and that your country does not endanger the following of these rules. That is, for example, why in the USA currently the data transfer from the EU is actually not possible based on the GDPR, because the CGEU has decided that the government can, whenever it wants, check on the data. So nobody, even when giving himself standard contractual clauses, can ensure the following of these clauses. So there is some hurdles still, even if you use the standard contractual clauses. It is, however, possible to establish this compliance. That is the very quick overview. I tried to keep it as fast and simple as possible. Of course, there is way more and complex topics to be observed here. I hope I can answer some questions in the Q&A. Some major takeaways. Data protection is as we all know, data by itself is a major business asset. The protection of said data is very important when doing business in the EU. Taking data protection into account from the beginning cuts costs in the long run. It is very burdensome to establish this compliancy once you've started your business, and it is of course that there's a high liability when doing so. So taking this into account from the beginning is very important. Two very important factors when doing so is you always have to have a legal basis, a lawfulness when doing so, and you have to be transparent when doing so. And the transfer of personal data from the EU to a non-EU territory requires appropriate safeguards, ensuring an adequate level of data protection. That is my very quick and dirty run over the GDPR and how to implement it for your company when doing business in the EU. When you have any questions, please ask me. Thank you for your attention, and I'll give it back to Ankita.
Thank you, Dr. Alexander, and thank you, Dr. Chandrasekhar. And what I've got, I mean, even 3 pointers specifically: transparency, adequacy, and appropriate safety measures, which plays very crucial role in safeguarding your data, because a lot more startups and even majority of the companies are now actually works on data. They breathe data. Data is new oil, and they breathe data. Yes, definitely. But I have a question for both of you, Dr. Alexander and Dr. Chandrasekhar. What do you think that now in India also new data protection and privacy regime is upcoming? I mean, most probably within few months we will get new law. So what do you think in the wake of that law, from the EU perspective, what EU side company will face? I mean, what do's and don'ts should be there for them? And from India side, Mr. Chandrasekhar, I mean, what do you think for Indian stakeholders? What do's and don'ts should be there as a takeaway for our audience from this session?
There are a lot of Indian companies who are doing business in Europe, mostly the IT companies. There would need to be all the Indian companies who are doing business in Europe will have to see the new data protection regulation. Following the new Indian data protection regulation should not in any way trip into any of the provisions of the EU GDPR. So that would need to be very carefully mapped out. So like for example, there could be a situation where there are employees of a European entity who are in India. The server might be in Europe, but the employees might be based here, and a lot of data might be going back there. Now, if that data is getting stored in India at the end of the day, is it going against any of the European norms? So such questions will come up on a case-to-case basis with different organizations depending on their operational model. So this would need to be mapped, and this is going to be a huge initial task. Because the companies will then have to decide whether to pay the fine in India or to pay it in Europe. And there could be a conflict of jurisdictions in that also.
Shall I contribute from the European side? Yes. Yes, that is indeed a very big concern. And from the European side, really one of the main factors would be the transfer of the data, which you have to where you have to save or ensure as adequate safeguards for the data protection in India. And that is at the moment a really big issue. As I've said, there have been decisions by the CGU concerning the USA where this adequate safeguard has been denied. So one of the major concerns right now would really be to establish adequate safeguards for the transfer of the data, which is possible, but which is at the moment not the easiest task, I would say.
Sure, I think and everything is depending on future and case-to-case basis as well. Even in European courts, CJU, and then in Indian courts, whatever case will come, like the software guidelines and all those things will evolve with the case-to-case basis. And I think now it's time for consolidation and word for thanks. So over to you, Julian and Hannah.
Julian, if you want to start from Ginsep end.
Sure, I can do that. Thank you very much, Hannah and Ankita, and particularly to all the panelists, all the speakers today. I found it really interesting, and we can see also from the participants they stayed on the same level throughout. That is always the sign that people are really into that topic, find it valuable, and really are really paying attention and take all the notes and information from it. So that was really insightful. I really enjoyed it to have it really in the perspective from India and from the EU to combine it, to compare it, since that's what we also see, that there's it's not enough to think about the business from just one side, but always in both sides, because it's global and interconnected. So that I found really helpful. And so particularly thank you very much to Dr. Daniel Herrmann, Dr. Alexander Tama, Dr. Chandra Deska, Hannah and Ankita from the EBTC. It was really nice. Also to all the participants, thank you very much. Also to Mighty Startup Hub, our another partner for this event, and I really enjoyed it. And please stay in touch. I'm also sharing my contact details here in the chat now, and see you next time. Also over to you now, Hannah. So that's it from my side.
Yeah, I think there is very little to add now. Things have been said, and I obviously, resonate with that. It was really nice and great cooperation, and even not just as the Indian IPSME helpdesk, but EBTC, we are very open to, continue creating such interactions, where we can share not just the Indian perspective, but also the European one, and have the mixed audience and look at it from both angles. So I think I can leave it with that. We are already 10 minutes late, so I'm sure everybody has busy schedules. So thank you very much for your time, and we are looking forward to catching up with you at some other event. And yeah, so have a lovely rest of the day. It's still here evening in India, and yeah, see you soon.
Yeah. Have a nice day, everyone, and
Thank
please
you,
share your
everyone.
feedback as well.
Thank you. Have a good day.
Thank you.
Stay safe. Bye-bye.
Bye.
Thank you. Bye-bye.